What's up, everybody? Welcome to the lab. I'm your host, Joshua Diaz. It's good to see you. Good to be here. Let me take this thing down. Hey, there you are. What's up, everybody? How are you? All right. Today we're going to be talking about this is a subject that's been going on for, God, I don't know how many years now. It's 1989, I believe it is, the Menendez Brothers case. And just when you thought, back, that you had this DA back in, I believe it was like October, November. People were believing that they were going to be released at some point. Some people thought even maybe before. I think some people even thought maybe before it was like Thanksgiving or Christmas. And I don't see how they go from they're on this track to get paroled, basically. And the guy that's pushing it, the district attorney at the time, who was all for it and says they've served their time. Well, he gets unseated by a guy that we're going to listen to here in a little bit. The district attorney, who now is opposing. He's actually opposing their resentencing. Says they need to stay in jail. Says that they're not suitable for life on the outside. And I know that there will be people in the audience people that watch this, that will say, that they've served their time. And then there's some people say they're cold-blooded killers. And some people will say, they were horribly abused as children, and that the parents, specifically the dad, but the parents in general, sort of got I wouldn't say got what was coming to them, because I mean that's just kind of a rude way to put it, but that there was, I guess you could say that there was a reason for it. And I don't know, I'm somewhere in the middle on this, and I respect everybody who feels that however they feel. So are they innocent? Do you all believe them? I don't know. I mean, I don't think that it's not that they're innocent. I don't think anybody, they admitted that they did it. They didn't have much of a choice, but they have three paths to freedom here. It's up on the screen. And clemency, which is, the governor can shorten their sentence, or he could just pardon them and they would be out today or tomorrow or whenever. He's had that for a long time. He's had that power for a long time, and that just doesn't seem like that's something that will happen. I don't see the governor stepping in. Sometimes it happens, but not always. And so it'll be interesting to see. Now, the resentencing, that requires parole board approval, and we're going to talk a little bit about that as well. But the parole board approval and governor approval, there's something that to be said there. Now, the habeas corpus one may, the new evidence, and they're going to get they're getting a new hearing. And somebody just said, let me see here. I saw somebody just say, I thought that they have sentence, or they have they have hearings coming up on the 13th. No, excuse me. Tomorrow's the 13th, the 20th and the 21st. And so that'll be pretty interesting. Yeah, well, this is part of the discussion here. We know they're guilty, horrible abuse, I believe. Yeah, I really don't know. I mean, I believe that there was something going on, but does it equate to murder? I don't, and probably not. But I want you to listen. We're going to listen a little bit, and I'll react to this. I am too, Jovi. I really am torn on it, but flat out, this district attorney does not believe that the reasonings for them doing what they did. He doesn't believe their sentence, or he doesn't believe in their defense.
District Attorney Maria Ramirez, Assistant Head Deputy
Let me make
Attorney
sure.
Crimes Division Habib Balian. We have John McKinney, Director. Contract that the Menendez case is justification for the new trial based on two additional pieces of evidence did not meet the legal standard to warrant a new trial. The second track that the Menendez case is on is the clemency track. This is a petition that the Menendez brothers filed directly with Governor Gavin Newsom. He could have acted on this petition either now, he could have acted on any moment since he has been in power since 2019. He can act on it today if he so chooses. He has unilateral constitutional power to commute the Menendez's sentences if he chooses and release them today. There is no hearing he needs to have. There's no deadline, and he can also do nothing. The third track is resentencing, and we are here today to discuss that third track. The resentencing is a law that was passed by the state legislature in California, a somewhat unique law to California, that basically gives the judge, under certain circumstances, the power to resentence someone who has been previously sentenced. In this example, potentially, the judge could resentence the Menendez brothers from life without the possibility of parole to life with the possibility of parole. Now, resentencing hearings get started in two different ways in this case. One of the ways is that the court has initiated these proceedings itself under Penal Code Section 1172.1A1. The second way it also got started is when the prior district attorney filed a motion under this code section to begin the resentencing proceedings. What the position we are taking today is that we will go forward. We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal.
Now, this is a good point here too. Is they absolutely did. There's no denying it. It was a brutal murder. It was premeditated. A lot of people are in prison and claim that they were abused and things like that. But there have been some things that have come up in the past, in the recent past, that may suggest that they may not have been telling lies about the abuse. And it's who knows, exactly where the truth lies with them. It's really hard to tell. I have more of a problem with the older brother, Lyle, than I do the younger brother. I don't find him as believable. Lyle, for instance, I think that he's a bit more, I don't know about now, but especially at the time, I think he was a bit more manipulative than his brother. And, but not saying that he was, I'm not saying that he's a monster or innocent or whatever it is. I'm just saying that his story and the kind of the way that he acted, I've always seemed to kind of have more of a problem with him. So, I mean, that's just how it is.
Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions. Governor Newsom gave us a primer on how this actually works when he dealt with the Sirhan parole recommendation that had been made to him back in 2021. At that point, Sirhan, who was the assassin of Senator Robert F. Kennedy in the Ambassador Hotel back in 1968 had been up for parole hearings 16 times. For the first 15 times, the parole board denied parole. But on this 16th time in 2021, the parole board recommended a grant of parole to Governor Newsom. So he looked at the case and he actually issued a written decision. And in that decision, he analyzed the factors that were both in favor of parole, and there's an analogy to resentencing, and the ones that weren't. The ones that were in favor for parole was that at the time of that parole hearing recommendation, Sirhan was 77 years old. He had been in prison for 54 years. He was suffering from a diminished physical capacity. In his childhood background, he had lived through a war-torn area. He was 24 at the time that he committed those crimes. And while in prison for those 54 years, he had engaged in comprehensive involvement in rehabilitative and self-improvement programs. He earned his Associate of Arts degrees and other certificates. He engaged his classification score, which is an analysis by the California Department of Corrections and Rehabilitation as to what type of risk level you're at, was at the lowest. It was a 19. In fact, the California Static Risk Assessment said it was that lowest level. His rule violation reports, that's the number of reports that he had experienced since he had been in prison since 1968, was 2. And the last one was in 1972. He had letters of support from prison officials, and he had letters of support from 3 of the 9 living Kennedy family members. Yet the governor looked at all those positive factors, recommending parole for Sirhan. Now it's in 2021, 2022.
Sirhan.
But he said that one factor overcame all those other factors. And that one factor is that Sirhan had not demonstrated full insight into his crimes. He had not completely accepted responsibility for his actions based on his multiple stories of what occurred that night in 1968. So notwithstanding the fact that he did not, he had all these positive aspects, and he had the parole board recommending a grant of parole, in January 12, 2022, the governor wrote that Sirhan poses an unreasonable risk of danger to the community and denied that parole. The reason this could be an instructive case is that there are almost no cases right now on Penal Code Section 1172.1, the resentencing statute. But the focus of it is the same focus as we have in the parole context. Is there an unreasonable risk of danger to the community by these particular people? And Sirhan, he was a murderer of Senator Robert F. Kennedy, and he shot 5 additional people that night. And here we have the Menendez brothers, who are murderers of their parents the night of August 20th, 1989. While Sirhan is 77 at the time that Governor Newsom made his decision, right now the Menendezes are either 57-year-old for Lyle Menendez or 54-year-old for Eric Menendez. They've served 35 years in prison. Sirhan served 54 years. They don't suffer from the diminished physical capacity that Sirhan does. They had also childhood allegations of physical, sexual, and emotional abuse in their childhood, while Sirhan had never been arrested or charged or convicted of any crimes before his offense. Eric Menendez had been arrested for multiple residential burglaries and received diversion. And Lyle Menendez had also been arrested for multiple residential burglaries. When it comes to rehabilitative programs, yes, both Sirhan engaged over the 54 years in significant programs, as have the Menendezes. When it comes to education that they earned, Sirhan earned an Associate of Arts degree. Eric Menendez has earned multiple Associate of Art degrees and is currently enrolled in UC Irvine. And Lyle Menendez earned.
So basically what he's going to get to here, he's going to tell you that there are 16 different things that they have lied about, and that part of the stipulations for being paroled or whatever it is that you want to call it, resentenced, or but he's got to go. They got to go in front of the parole board. Is that to they need to admit to their lies, which he believes are lies, and he'll talk about this a little bit more. And I know that there are going to be people say, "Well, they're not lying, or they are lying, or they." I get it. It is a very, very messy thing, and eventually, I think eventually, probably because of the public pressure, that they will eventually be freed. But this district attorney is not going to make it easy on him. I don't really have an opinion on whether they should be freed or shouldn't be freed. I know what they did was, I mean, it was a horrendous, horrendous killing. It was a premeditated. I have a major problem with them killing the mother, more so than the father. But I don't believe in murder in any way, shape, or form. That's kind of my stance on it. But I don't doubt that they were mistreated and abused. I really don't. Um, but the mother part really, is like, it was almost like they were trying to say that it was a mercy killing. Uh, and I just think that that's a bit, I don't buy that.
His Bachelor of Arts degree from UC Irvine. As far as classification scores, they're all at the same level, a 19, which is considered the lowest level you can be at in the prison system. With respect to that California static risk assessment, they're all at the lowest level. Rules violations, you had 2 for Sirhan, the last one in 1972. You have 9 for Eric Menendez, the last in 2021, and 8 for Lyle Menendez, the last in 2024.
Oh, Suzette, I understand. I completely understand what this is about. What this is about is to be rehabilitated. They want people to admit. You know how many people are in prison and will not admit what they've done, and that they fudge what they say? They say, well, I did this because of this, and I did this because of that, instead of just saying, that, that's what this is about. This is about them receiving a chance at freedom. And basically, parole boards don't like when people kind of fudge with it. The Menendez brothers are in prison for murder of their parents, which they admit to, and they also have to be rehabilitated. And I mean, they were sentenced to life without the possibility of parole, which is pretty typical for like premeditated murder. And that's what it was. It was premeditated murder. Now, I'm not taking away anything that they did or anything that had happened to them, or whatever, but they have to actually meet the standard for an early release. That's all I'm saying. And I'm not saying that they are or they aren't.
They each have letters of support from prison officials, and the Menendezes have multiple letters from all living victim family members, aside from one who recently passed. And they received those letters in support of their being released. With respect to them, the key issue of exhibiting insight, full insight into their crimes, and completely accepting responsibility for their actions. This is where the Menendezes, like Sirhan, also fall short. As we lay out in our pleading, which is now 87 pages long, we go through a 60-page statement of facts, which is different, by the way, than the 3 pages that the prior motion had laid out as far as the crimes that are involved. And as we show, the essence of the defense that the Menendezes have maintained from the first trial into the second trial to the present day is that they acted in self-defense. They had an actual fear of imminent harm, in essence, that their parents were going to kill them the night of August 20th, 1989. As we show extensively, just to make this point, that this case is not, or their defense was not about sexual abuse, because I know that issue has come up many times, but about self.
And there is the legal standard that he's talking about. They said that the reason, no, Kelsey, that's not what they're wanting them to say. They're wanting them to say that they were not in imminent danger the night that they killed their parents, because their defense claim is and was that they were scared for their lives and that it was imminent that they were going to die. They don't buy that. And they're going to tell you, and he's going to tell you why he doesn't buy it.
Self-defense. I take you to both Eric Viles and their own attorney's statements. At trial, Eric testified, and he was asked, "Did you kill your father because he sexually molested you?" Answer, no. "Did you kill your parents because you hated them?" Certainly no, was the answer. "Did you kill your parents because you wanted their money?" Answer, no. "Did you kill your parents as an act of mercy?" Answer, no. "Why, Mr. Menendez, did you kill your mother and your father?" Because we were afraid. "What is it you were afraid of?" "I was afraid of dying." "Who were you afraid was going to kill you?" "My mom and my dad." Lyle Menendez similarly testified as well. That on a question on August 20th, 1980, "Did you or your brother kill your mother and father?" "Yes." "Did you kill them for money?" "No." "Did you kill them because you wanted to pay them back for the way they had treated you?" "No." "Why did you kill your parents?" "Because we were afraid." That is the essence of their defense at trial. It was not sexual abuse. The jury was never asked to render a verdict on sexual abuse. It was all about self-defense. In fact, Eric Menendez's attorney, Leslie Abramson, said, "We have never said that because you're abused, you're justified in killing your abuser. We didn't argue that and never will." So the question then is, have the Menendezes exhibited insight into the fact that their self-defense was fabricated? And as we go through the iterations of their defense that they issued from the time that they were arrested until the time that they went to trial, until the present day, what you will see is that the self-defense was the last iteration and version of their defenses. Because remember, the first defense that they came out with was, "We didn't do it. That's not us." If you remember the 911 call, if you remember Eric Menendez screaming and crying when the police came out that night, he says to the police, "We're going to kill them," referring to the people who just murdered his parents. "We're going to kill them. We're going to torture them." Who would have done this thing? The answer is the Menendezes. But their first iteration wasn't that. It was either the mafia or the cartel or the dirty business association.
Yeah, and I mean, I get what he's saying. Yeah, okay, of course. Initially, they lied at first. I mean, who's going to want to admit that they killed their parents? I mean, I guess some people would probably very rarely. Initially, I mean, they were, you know, I don't know if they were looking to get away with it or what. I mean, it seems like they probably could have, if Eric hadn't talked to his attorney or talked to his therapist.
Jose Menendez. They persisted in this lie, not just the night of August 20th, but kept that lie going for months and months and months. And had Eric not confessed to his therapist, Dr. Oziel, months later, and that confession been taped, and that confession's tape been turned over to the police, they would have maintained it wasn't us. They convinced not just the media, not just the police.
You don't like watching when it's just me? Sorry. I don't know. I mean, I'll schedule one when I don't know.
Police, but their family and their friends. that they were 100% innocent of these crimes until eventually these tapes came out. They were arrested. And then they changed to the next iterations, because the next iteration of the story was when Lyle Menendez gets his girlfriend, Jamie Pisarek, to visit him at prison and says, I want you to testify that my father drugged you and violently raped you, establishing that Jose Menendez was a violent rapist. Jamie Pisarek refused to do that. So the next iteration of the story was that Lyle Menendez asked Jamie Pisarek and said to her, well, Eric Menendez was raped by my father, but I was raped by my mother. That's a story that was then repeated to Eric and Lyle Menendez's uncle, Carlos Parole. That Eric Menendez was molested by the father, but Lyle Menendez was molested by the mother. That iteration didn't go forward. The next iteration that ultimately came out at trial and just before trial was that both boys were molested by the father. But as you heard a moment ago, that wasn't a defense to the charges of first-degree murder with special circumstances, because you had to add one more thing that the jury was now going to consider, is not just that they were sexually abused, but they were actually in actual fear of imminent harm, of their lives being taken by their parents the night of August 20th, 1989. So self-defense is the defense that they set forward at the trial. But what we show in our pleading is we go through the timeline to show that the Menendezes have basically engaged in not just the ultimate lie of self-defense, but a whole series of lies around it. And they took actions that were both premeditated and deliberate, not just sort of immediate responses to their parents somehow threatening them the night of August 20th. We point out that days before the murders on August 20th, on August 18th, the Menendezes drove 120 miles to San Diego to purchase shotguns and ammunition and use a fake ID and a fake San Diego address to make sure that the guns and the ammunition would not be connected to them. The day before the killings, August 19th, they go to a firing range and they find out that the birdshot ammunition that they had bought isn't good enough to kill someone. They're told you need buckshot ammunition in order to actually kill someone, and they buy it that day. Hours before these killings, at roughly 10:20 p.m. on the night of August 20th, Lyle Menendez contacts one of his friends, Perry Berman, to set up the alibi. And the alibi was that they were going to go to Batman the movie at the 8 o'clock showing. And they would be at that movie when the killings would have occurred, and then meet Perry Berman at the Taste of LA event afterwards. They set this up before the killings. Now, during these killings, as we've explained before, these weren't just a situation where all of a sudden the parents threatened their lives, they reached for something and shot them dead. No, these killings, the actual shots, were designed to make it look like a mafia gangland hit. They shot Jose Menendez through the back of his head. They shot Kitty Menendez not only once, which then caused her to go down to the ground, bleeding, but when they ran out of ammunition, they went back to the car, reloaded the shotgun. Then Lyle Menendez took the shotgun, put it up to Kitty Menendez's face, and pulled the trigger. Again, to make it look like a gangland shooting, but that was not enough. They then, while they were dead, shot them in the kneecaps to make it to complete the picture of what a gangland shooting would be. And at that point, they also had the presence of mind to pick up all the shotgun shells that were lying in the den, because they were worried their fingerprints might be in them. They then called Perry Berman to establish the alibi and went to the movie theater to buy the tickets, only to find out.
I mean, like I said, I get it. I get people on both sides of it. I completely understand how anybody would feel.
They couldn't buy the 8 o'clock showing because the next showing had already occurred. And Perry Berman had already moved on to a different event, so they couldn't.
Well, this is a great question. Do I think that they should be released? I have many problems with what they did, the way that they did it, the way that they went about it. Um, it was brutal, it was violent, and it was calculated. Um, I mean, as somebody that has sat and listened to the parole boards before, I get what he's saying. I understand what he's saying. Um, but I also get what they did. Uh, and I don't think that there's a really easy answer. Honestly, I mean, I wish I could just be like, yeah, I think they should be out of it. I don't know. I don't know. I just don't know.
Meet up.
I have a major problem with the accusations that that I believe that they were abused. I do. Um, I don't know. I take them at their word of the type of abuse that they went through and things like that. I get it. Um, I mean, it was a pretty horrific crime.
With him. So they took all those shotgun shells, they took the bloody clothing, they go to a gas station dumpster and they dump it in the dumpster. But now they got the shotguns, what to do with them? They had the presence of mind to drive up to Mulholland Drive and throw the shotguns off the hill on Mulholland Drive. They then went back to the house. When they get back to the house, that's when they made the 911 call that someone killed our parents.
Yeah, Sonia, I get what you're saying, but the trial, it wasn't about sexual abuse. I mean, they said that the reason that they killed them was because they thought that they were in imminent danger and afraid for their lives. That's what they're talking about.
And then when the police arrived, that's when they said, as I said before, when Eric and Lyle are running out screaming and crying, and Eric says, I'm going to kill them, I'm going to torture them. Who would do this? Knowing, of course, that it was him and Lyle who had done that exact crime a little more than about an hour and a half beforehand. So you had a situation then where thereafter they engage in this deception.
Yeah. So here's
hoax, the lies to their.
here's kind of what sometimes they say the cover up is worse than the crime. Their actions after their parents had died raised a lot of questions about them, and um, you know, just sort of the way that they acted. I mean, wasn't it didn't I don't know didn't see it wasn't great. Let's just put it that way. But um, uh, Kelsey says I can understand why they did what they did without believing it was the right thing to do. Recognizing the impact of trauma isn't the same as excusing their actions. Yeah, well, I mean, if they don't, okay, but here's the thing: if they don't understand that murder is wrong, then I mean, there's a major problem there as well. I'm sure that they knew what murder was wrong. I mean, it would be. Hmm. Well, you'd have a whole lot of dead mothers out there, Julie.
Friends, their
and you'd have a lot of free people walking.
family, the media, and the police. And what's interesting as well is the actions they take immediately afterwards. If these were kids that had just lost their parents, you would think the last thing in their mind would be to check on where the will is. But sure enough, within 48 hours, they go ahead and obtain the computer that they believed a new will had been written on, disinheriting them, bring in a computer expert to delete and then double delete all the files dealing with Eric, Lyle, or Will that are on the computer. go ahead and remove the safe from the family home into a neighbor's home to look at the safe only to determine there was no will in that. And then even go to the bank safe deposit box to go ahead and see if Jose Menendez had put the new will there, disinheriting his sons as he told them he was going to do. So the story again keeps going on. And today, Eric and Lyle Menendez, at least from the beginning, fully expected for them never to go to prison because they had successfully convinced everyone that they didn't do it until they spoke to Dr. Oziel. And Eric, feeling the pangs of guilt, feeling even suicidal, talked to Dr. Oziel and basically told Dr. Oziel that they had done it. When asked about why they killed their father, they didn't mention self-defense. Why they killed their mother that night, they didn't mention self-defense. What they said about the father, what Eric said, is that he was a controlling, dominating force, and that is the reason that he was killed. When he was asked about the mother, he said the mother would be a witness to the crime, so she had to die. That the mother was so miserable because the father had had an affair that we needed to put her out of her misery.
Right.
That the mother could not live without the father, and if we were going to kill the father, we had to kill the mother. What doesn't happen in any of the tape conversations with Dr. Oziel, and remember, he is being brought on by the attorneys to eventually go ahead and prepare a defense to the murder charge. So what they never tell Dr. Oziel in all the tape confessions is that they were in any fear of their life, that their parents.
No, the thing is that basically he's saying that, for a resentencing, which would have to be approved by a parole board or, the governor or whatever, however that goes. He's asking them to admit that they weren't in fear for their lives. Not that their trauma didn't happen, not that any of their abuse didn't take place. He's talking about the specific reason their defense was that they were in fear for their lives, which a jury didn't buy. There's they went through two different trials. And yeah, so that's pretty much that.
Going to kill them that night or any night, and that they experienced sexual abuse by the father. So the story then goes on because once they get into jail, additional lies come up. I've spoken before about the lies that Lyle tried to tell with Jamie Pizarnik about her being violently raped by Jose Menendez. They also enlist another of Lyle's girlfriends, Tracy Baker, where Lyle literally writes her a script, a letter that is found later that lays out a story of the mother trying to poison the Menendez brothers and the entire family. Tracy Baker actually testifies to this false story in the first trial, though not in the second.
It's kind of his.
And not only
look, this is a big. It's been a big case for a long time, and it's kind of fallen into his lap. So
that, but Eric and Lyle Menendez each testified to this fake "mom's going to poison us" story. What we also find out is that Lyle enlists one of Eric's friends, a guy named Brian Eslamania, to go ahead and corroborate the self-defense story. How is he going to do it? Because the letter that Lyle writes to Brian Eslamania, which is actually found by the police, he has detailed instructions down to the actual word that Brian's supposed to say that the day before these killings, the Menendez brothers came to him to get his handgun in order to establish that they had this fear of their parents, even at 24 hours before, and tried to get a handgun. That is actually disproven. And when it's disproven, again, Brian Eslamania says, look, I didn't have that conversation with the Menendez brothers, and I didn't even have a handgun to give them, even if they said that I did. So you had these situations. The Brian Eslamania attempted suborning perjury. The Jamie Pizarnik attempted suborning a perjury, and the Tracy Baker actual suborning a perjury that the Menendez brothers engaged in to establish this self-defense, but it failed. And the reason we know it failed is that a jury heard all this evidence. And the jury, the second jury, the first jury hung, but the second jury that heard all this evidence rejected the self-defense and found them guilty of first-degree murder for both parents with special circumstances. And what's also important to note is that this conviction has been run by 5 different courts over the last 30 years. It went to the California Court of Appeals. It went to the California Supreme Court twice. It then went to the U.S. District Court. It then went to the U.S. Ninth Circuit Court of Appeals. The Menendez has brought up every single argument that they bring up now about the faulty jury instructions, the exclusion of certain sexual abuse evidence at the trial, about certain other court rulings, and it's been rejected and rejected and rejected over and over and over again. So, in looking at then whether or not the Menendezes have exhibited the full insight and complete responsibility for their crimes, they have not. Because, and we outline this in 20 different lies that they have told, which is an attachment to our submission. They have told 20 different lies. They've actually admitted to 4 of them, but 16 lies remain unacknowledged. They persist in these lies to this very day. So like with Sirhan not being able to exhibit full insight into his actions, so too the Menendez brothers failed to exhibit full insight into their actions. Let me give you 4 examples where they've actually admitted to the lie. Eric and Lyle lied on the 911 call about just discovering their parents' bodies. Again, when they were found out and the tapes came in, they admitted to that lie, and I mean the lie of the 911 call. The second lie that they've admitted to is that they lied to the police, family, and friends and the media about their involvement in the murders. Again, when their confession came out on tape, they had to admit to that in the first and the second trial. They admitted that they lied to the police, family, and friends, suggesting the mafia was involved in the murders. And Eric admitted that he lied when he told his expert psychiatrist, Dr. Vickery, that his parents would kill him because his father's homosexual lover warned him that he was in danger 2 days before the murders. This is something that Eric Menendez told Dr. Vickery, and then months and months later finally recanted and told Dr. Vickery that that was a lie. But there are 16 lies that remain to this day that have been affirmed as recently as last year, where they affirmed the self-defense and they never admitted to the suborning of perjury of others or the attempted suborning perjury. These lies include when Eric and
so before he gets into this, I am curious where everybody sits. Now this kind of stuff is the stuff that really, really bothers me. That Lyle, I believe it was Lyle, was trying to get people to lie for him and admit things that didn't happen. And that's the, are you talking about Menudo? Yeah, I mean that's something else too. This is kind of the part that bothers me, especially about Lyle. And then he gets recorded by some lady. It's just an idiot. It was an idiotic thing to do. It really was. And it kind of screwed him in the long run.
Lyle claimed that their parents were going to kill them, that they had to act in self-defense by murdering them first. That the Brian S. Lamina letter, that they basically tried to suborn perjury from Brian S. Lamina, telling him to testify that he borrowed one of his handguns the night before the murder. Another lie that they told to support their self-defense story is that on that Friday, when they go down to San Diego, they said they actually didn't start in San Diego. They said they started at the Big Five sporting goods store in Santa Monica to try and buy handguns. That unfortunately there was a 14-day waiting period, they said, so they couldn't buy the handguns at that Big Five sporting goods store in Santa Monica. They both testified to this. Turns out, as the evidence came in at trial, the Big Five sporting goods store in Santa Monica hadn't sold handguns for 3 years at that point. So it was impossible for them to have actually gone and seen and tried to purchase a handgun instead of a shotgun that particular day. They've never admitted that they provided that fake ID and fictitious address to buy those shotguns in San Diego in order to conceal their connections to the shotguns and the ammunition. They just said that they used a fake ID because they had driven all the way down to San Diego and forgot their California driver's licenses. They testified that the day before the murders, they had stayed away from the home all day that Saturday, even though a witness came forward, who was the pool repairman, who said they were playing tennis that day at the house and disrespecting the parents who were in front of them. Again, another lie which they have never acknowledged. They lied when they said they didn't plan that alibi before the murders. They lied when they said they did not ask Perry Berman to come back to their house in order to be a witness on the discovery of the mutilated bodies. They lied when they said that they did not stage the murders to look like a mafia gangland hit. They lied when Lyle said they tried to suborn that perjury from Jamie Pisarcik about his father drugging and violently raping her. They never admitted that they lied when they testified that their mother was so dangerous and unpredictable that she tried to poison the whole family. And they've never admitted the suborning of perjury from Tracy Baker, where they actually got one of Lyle's girlfriends to testify to the fake mother's poisoning the family story at trial. They further lied when they testified that they thought their parents were going to kill them during their Saturday afternoon.
Yeah, Rugg says here, I feel guilty that I'm a victim, yet I don't think they should be paroled. This is complicated. I don't think that you should feel guilty about how you feel. I don't think that there's a right. I mean, I'm sure there are people that are going to go, there's a right or wrong answer. I don't think that there is, um, because just from everybody's experience, everybody's going to feel different about this. I feel different in a way. There are two different parts of me that struggle here, and one of them is somebody who sat in front of parole boards for years, um, knowing that even if you're telling the most minuscule of lies, the remorse or the rehabilitation isn't complete. That's a big reason that my father has never received parole, because he doesn't. It's the little things that they don't admit to, and they have lied about things. There's no question about that. Are those mitigating factors enough? I don't know. But don't feel guilty about anything about how you feel. You should never.
Afternoon fishing trip. They lied when they testified that when they burst into the den with their shotguns, that it was too dark to see and their parents were standing up or moving towards them. Expert testimony showed that at all times the parents were seated on the couch when they were shot, or mom was on the ground bleeding to death when Lyle came back and shot her in the face. They lied when they said that they testified that the reason they rushed in on their parents was because of self-defense, and they thought that their parents were going to shoot them first that evening. And they lied when they testified that Dr. Oziel blackmailed them into confessing on tape to murdering their parents.
Yeah, they have. Yes, they got in trouble when their father cut them off when they were younger. They decided to start burglarizing homes, and they did. And then once they got in trouble for it, their dad sort of bailed them out, I guess.
We lay out this series of 16 of the 20 lies that they have never acknowledged, never showed insight into, never completely accepted responsibility for. By the way, what I just described to you was mentioned in a paragraph in the original motion that was filed by the district attorney's office. There was no discussion of exhibiting insight into one's actions or completely accepting responsibility for it in the original motion. So we are basically, in some ways, offering a path to the Menendez brothers. And here's what the pathway looks like. If the Menendez brothers at some point.
All right. Before we get there, and Eve loves God. It's good to see you, Dr. Eve. They shouldn't be forced into saying they weren't scared. Even if they did, how would they know they weren't lying just to get out? It's a ridiculous stipulation. Well, first of all, they're not, even if they do admit it, then that doesn't mean that they're going to let them out. And second of all, I don't think that they weren't saying that they were scared, but they were scared for their life in that moment. So that's why why they had to kill him. I mean, there's a whole premeditation to this. That's the big problem. The premeditated, like he said earlier, it wasn't like he was just sitting there and then all of a sudden somebody reached for a gun and then they reached for a gun. That's it. I mean, so I don't think that they're just telling them that they were in that exact moment because they were out fishing the day before they were on a fishing trip. But in that exact moment that they were not afraid for their lives, not that they hadn't been abused. Nobody's telling them that they can't say that they were abused or sexually assaulted or whatever that they say. They're not telling them that, but they're basically saying, look, you guys lied about the reason that you did. And so that's sort of what they're saying. That's kind of what they're saying.
Unequivocally, sincerely, and fully accept complete responsibility for all their criminal actions. Acknowledge that the self-defense
like 18 and
phony, and their parents
18 and 21, I think,
going to kill them the night of August 20th when they murdered them in cold blood. Acknowledge that they suborned or attempted to suborn perjury in all the various ways I have outlined. If they go ahead and finally come clean with the court, with the public, with the DA's office, with their own family members, and acknowledge all these lies, and then can be said to have fully and completely accepted responsibility for their actions. In the future, the court can weigh these new insights into making a determination as to whether they now qualify for rehabilitation and resentencing. And the people will do the same. The district attorney's office, if it is presented with these new insights, unequivocal, sincere acknowledgments of all the lies they have told for the past over 30 years, we too, in the district attorney's office, will reconsider whether or not we would want to go forward with a resentencing motion. But for now, while the Menendez brothers persist in telling these lies for the last over 30 years about their self-defense and persist in insisting that they did not suborn any perjury or attempt to suborn perjury, then they do not meet the standards for resentencing. They do not meet the standards for rehabilitation. They have not exhibited the full insights and accepted complete responsibility for their actions. And as a result, just like in the Sirhan case, they pose an unreasonable risk of danger to the community, and the resentencing should not, therefore, be granted. I'm going to stop now. I'll take any questions.
So the Sirhan thing, I don't know why he just keeps going on that, but I don't think it's. What's up, Kat? How you doing, man? And Lolo, thank you for being a member for 3 months. I appreciate it. Sirhan. Just like tired of hearing that guy. This guy's staking his entire. I get that, like when you're talking about legal matters that you want to have some precedent and something that it could be shared with, but Sirhan.
That anyone has. After I'm done with these questions, Maria Ramirez will address the Spanish-speaking media and provide information at that point.
The hearing is on March 20th and 21st. It's word that they have been postponed. Is that it?
So those hearings, whether they occur on March 20th or 21st or at some point later, first it's up to the court on what the court ultimately wants to do. The court is receiving our response today. We anticipate the court may keep the March 20th and 21st dates to deal with our response. Both again, part of our response is to go forward with the court's initiated motion for resentencing, and part of our response is a request to withdraw the DA's motion in this regard. The court might have the hearing then on that issue, and then if in fact it decides to go forward with the full resentencing, set a hearing in the future. I know that the governor has now ordered the parole board to do the risk assessment. That risk assessment can take up to 90 days. We don't know when it will actually be completed. The court may or may not want to have that risk assessment done before it has the final resentencing hearing.
Yeah, can you just clarify? So obviously you've laid out this case. This reply motion will be in the file no matter what, but you cannot pull back Gaston's motion. You're asking the court to pull that away. If they decline in this hearing, the court will then have to weigh both motions equally. How does this play out in that?
Effectively, yes. So what will happen is, again, you have in some ways double motions going forward. And in looking at the different motions, we have now analyzed the original motion filed by the district attorney's office and saw that in no way, shape, or form did they deal with what we believe to be one of the key issues, this exhibition.
Yeah, I think he
of
has.
insight and
I'll listen to what he
complete
said.
responsibility for one's crimes. So we are pulling back or asking the court to withdraw that motion, while we're also indicating to the court that we're prepared to go forward on the court's own motion for resentencing.
Considering all the facts that you've brought up, do you think there's any chance the Menendez brothers are going to get out of jail in the next few years?
Again, we have laid out a pathway for the Menendez brothers to potentially get out of jail. It requires them to finally, after 30 plus years, fully acknowledge and completely accept responsibility for the entire breadth of the crimes and all the lies that they have told, including their defense at trial of self-defense. If they go ahead and do that, and they do it unequivocally, and they do it sincerely, ultimately the judge is the final arbiter of the sincerity and whether or not this is just being done to please someone, or whether or not the Menendezes have fully come to grip with the lies that they have told. Again, they had no problem at trial coming to grips with the fact that they had lied for over 6 months to the police, the media, their family, and their friends about the fact that they never did it, were not involved at all, and it was the mafia that had actually done the hit on their parents. So they have a history of acknowledging some lies. I'm hoping that they continue with this evolution of themselves, their improvement of themselves, to finally come to grips with the acknowledgement of the totality of their crimes and their lies. And at that point, the court may very well entertain the idea that they have met all the criteria to not only be rehabilitated, not only no longer pose a danger to society, but to be resentenced.
But you don't think they're getting out of jail until they do that?
Our position is that they shouldn't get out of jail. Now, ultimately, that is a position. We bring that position to the court. The court can agree with it, the court can disagree with it, or modify it in some respect. I'm sure that the Menendez's lawyers will be arguing that the court should go forward now with the resentencing. I've spoken to the Menendez family members.
It's a new
By
district
the way,
attorney.
I spoke to the Menendez family members who support the Menendez brothers before I spoke to Milton Anderson, who recently passed. I spoke to him after I spoke to the Menendez family members, and they certainly would like them out, tomorrow. And they'll be encouraging the judge to do the resentencing now. But as we have looked through the facts and the law, and that's what's governing our opinion. It's not emotion, it's the facts and the law. They have failed to meet these requirements to show that they are no longer an unreasonable risk of danger.
I gotta agree with you.
And that is why our position is that resentencing, if it occurs, they shouldn't actually be resentenced.
A note on the family.
Have you called the family by any chance and notified them of your decision? We have not actually spoken directly to the family today. We filed this at the earliest possible time we could at 8:30. We're having this press conference at 10. But when I spoke to the
Well, I
family
mean,
before,
people are allowed their
we had a
opinions, aren't
3-hour
they?
Meeting with the family members, the over 20 family members that support the Menendezes being released. And we talked about their rehabilitation in prison. We talked about their beliefs of what happened at the time of the crime. We had a very wide-ranging conversation, and I sat there and I listened to it all. But it does not eliminate the fact that in order to show a full and complete acceptance of responsibility and show full insights into one's criminal actions, that as we have laid out in detail, the self-defense defense was a fabrication. They need to admit to that. They need to admit that they suborned or attempted to suborn all the perjury. And at that point, we might be in a position, if they do it sincerely and unequivocally, to be in a position to then go back to the court and recommend resentencing.
D. Hoffman, on the note of the family.
What if they do that in the next couple of weeks before the resentencing hearing? They acknowledge everything, and would you find that to be sincere? Would that change your
Given that
opinion?
you talked about all the lies they've said, how would anything that they would tell you, how would you deem that to be sincere after you've gone through this whole litany of lies that you claim they've made?
I will address that in the same way that people ultimately were able to believe the Menendezes when they admitted to the first 7 lies, the first 4 lies. Because remember, at that point, you had a situation where the Menendez brothers said, we didn't do it. The mafia did it. But they took the stand repeatedly at trial and said under oath that no, we lied when we said we didn't do it. We lied when we said the mafia is the one who gunned down our parents. And they were able to, again, express under oath that belief, and they did it over and over and over again. So if the Menendezes go ahead and want to, at any point, whether it's today, whether it's weeks from now, months from now, or years from now, finally and unequivocally express that they and acknowledge the lies that they have told and persisted in for over 30 years, then we will certainly evaluate the quality of that sincerity and decide whether or not it's real or fake, whether or not it's just designed to get out of jail, or whether or not they truly believe and acknowledge the full breadth of the crimes and lies they have told in deciding what to do at that point. And as importantly, the court will have to make that decision. And that decision is the court and the courts alone to make.
Yeah, the family filed a Marcy's Law complaint. I'm sure you've seen this with a wildly different characterization of the meeting than you've offered in the past. They are actually claiming you were hostile towards them, that there was a bias and asked if you were moving to the case. I don't know if there's any, obviously offered a different characterization of that meeting. Do you dispute that, the description that they made?
So it was a 3-hour meeting. And remember, the district attorney is not obligated to meet with any of the family members, not even obligated to necessarily, certainly not obligated to meet in person. I could have taken
he's got
communications from any of the family members and actually
he's got a big say in this, and they work closely with judges, and so I mean his opinion will go a long way whether you like it or not. Doesn't mean it's the end all be all, but
we did receive some written communications, but I sat there for over 3 hours. I didn't tell any of the Menendez family members what to say or what I wanted them to say. I said, whatever you want to say to me, please say it. And I sat there and listened to everyone who wanted to speak to me until they were done speaking. So if they've characterized that meeting in whatever way they're going to characterize it, so be it. I understand that the Menendez family members the ones that are supporting this, want the Menendezes out today. They could go to the governor. They wanted to actually achieve that. Literally go to the governor Newsom today, and he could commute their sentences and release them today. I, on the other hand, am bound by the facts and the law as it pertains to an analysis of whether or not resentencing is appropriate. And that is what I've done. Again, the jury heard this self-defense defense way back when, and the jury rejected it. We're just basically, in many ways, following the jury's verdict from way back then, while the Menendezes have for over 30 years not only rejected the jury's verdict, but persisted in the lie of self-defense and the related lies I've talked about in the back.
Why
Yes.
still go through with this while it's in the governor's hands? Some could say it makes no sense.
Can't hear the question.
Why go through the resentencing? That's actually up to the court. The court can decide to continue a hearing and wait for the governor to weigh in. The court can keep the hearing on March 20th and 21st. District attorney is not going to tell the court what to do in this respect.
I think what was he saying? I think that it was talking about that they were. I think the big one is that they weren't afraid for their lives in that exact moment. That they were saying that it was a self-defense. Like to claim a self-defense case, you would have to sort of say, well, not sort of. You would have to say, well, the reason I did this is because this person pulled a gun on me or had me in a chokehold or was kicking me in the head or so on and so on. Not busting into the family room. What happened? Hello? What happened to your ears? I'm sorry. Yeah, it's the imminent danger part. So I don't know. It's supposed to be 16 lies. I don't know. I don't know all 16 of them.
What about
Yes, over here.
what about the issue of the age they were when they committed these crimes and how laws have changed with regard to life without the possibility of parole?
A good point. Sirhan was 24 years old, and the law says that youthful
Sirhan.
offenders are under the age of 26. If you actually look at the governor's decision dealing with Sirhan, he mentioned that he has to give special consideration to the age of a particular person, particularly if they're under 26, that the law requires. And so too, for resentencing, should the court give such consideration to the age of the offender. Sirhan was 24, Lyle Menendez was 21, Eric Menendez was 18 when they committed their murders. So yes, we need to give that consideration to the age of the offender. And I use the example of Sirhan, where that consideration was given, but yet the failure to exhibit full insight into one's actions and completely accept responsibility for the breadth of one's crimes overcame the pro-parole factors that the governor considered.
Going back to what the family had claimed in their letter to the U.S. Attorney's Office, beyond how they framed the meeting, they say in an ongoing way you are biased against the Menendez brothers. How do you respond to those things?
I am not. As I've said, not only am I not biased, but I will file the facts and the law wherever they take us. And in fact, so much so that I've explained in quite long detail exactly where the lack of insight into their criminal actions occurs. I've outlined 16 different lies, 20 lies total, 4 of which they've acknowledged, 16 of which they have not. So I've outlined a pathway in the district attorney's position on how the Menendezes could exhibit these new insights. Now, whether they're sincere, whether they're unequivocal, that's between the Menendezes and mostly the court as to whether or not the court actually believes that. But if that were to occur, then I've said the district attorney's office, if it believed that these new insights were sincere and unequivocal, that we would reconsider whether or not we would go forward on a resentencing motion.
What's up, Mr. E?
Your new filing is 60 pages, and filing from the previous DA's office was just 3 pages.
What I meant to reference, if I wasn't clear,
It was 60 pages. He filed 60 pages. Holy crap.
is our statement of facts dealing with the crime was 60 pages. The statement of facts dealing with the crime in the original motion was 3. And if you look through, I'm sorry.
Thank you, Mary. I appreciate the thought-provoking conversation. I appreciate it. Thank you very
Do
much.
you think that was incomplete? Do you think they did a poor job or poor framing?
I think it was incomplete because they never undertook the key analysis of whether or not the Menendez brothers have exhibited this full insight into the breadth of their criminal actions or completely accepted responsibility for all of them. As a result, we spent And also the original pleading focused mostly on the probation report, statements made in the probation report. We went to the trial. If you actually look at our 60 pages, there are references to trial transcripts. There are references to court appellate opinions that analyze the facts. We didn't rely on a probation report where a probation officer is summarizing testimony, where that testimony is not under penalty of perjury and not subject to cross-examination. We went back to the source materials. Now, what was involved in that? It was a review of most of 50,000 pages of trial transcripts from 2 months long trial, thousands of pages of prison records, hundreds of hours of videotaped testimony. We also spoke to prior prosecutors, defense counsel, the Menendez family members, as I mentioned, and law enforcement. So we did as best over the last several months a full debrief and download on the Menendez case to arrive at the position that we've arrived at today. I'll take one more question right here.
Who would they have to tell that they accept or take responsibility for those
The
lies
court.
or actions? Who would they have to express it to?
They can do it in any form. Ultimately, it has to be to the court, because the court will be the arbiter and the judge of whether or not the Menendez brothers have finally exhibited full insight into their crimes and completely accepted responsibility for them. So, however, the Menendez brothers want to convey that sincerity and that unequivocal admission that they have lied to everyone for the past 30 years on their key defense of self-defense, suborning perjury, and attempting to suborn perjury, I will leave to the Menendez brothers and their counsel.
So there you go. So he's saying that they perjured themselves. They haven't admitted to doing that. They attempted to perjure themselves, and that they asked other people to take some, or to lie for them. So I believe that's what they're referring to there. Let's see. See if that's the end of that.
It has to be during a hearing or
They
something.
can be in any form. They can do it with declarations. They could do it with videotaped testimony. They could do it at the actual hearing itself. I'm not going to in any way suggest how they do it. They have a very qualified counsel who can advise them how to do it. It's up to them, though, on whether or not they want to do it.
Yeah, the thing too is, I mean, maybe they just do it to get out. I mean, is that what you want? I mean, not saying that they do get out because they admit to something that they have lied about. They're just saying that, look, we will think about it, and God knows.
All right, I'm gonna stop right now. I will turn it over to Maria Ramirez for any one-on-one interviews. They'll be in the green room. And thank you very, very much for being here today.
All right, one second. Yeah, I'm not really, like I said, I'm not really the whole, you got to admit it. You got to admit that you lied. I mean, I understand why they want him to do that, but I don't know. Hold on. There we go. Let's listen to a little Ashley Banfield here.
If there was still any doubt where the district attorney of Los Angeles stood on the question of Lyle and Eric Menendez getting out of prison, tonight there's a whole lot less of that doubt. DA Nathan Hochman just announced his opposition today to.
Well, I mean, if they lied, part of being released from it's the law. I mean, I get it, but that's the law. That's how parole boards work. That's how resentencing works. you know. Yeah, he did talk a lot.
One of the pathways to freedom for those two men, a resentencing, which is a process that would make them eligible for parole almost immediately. The DA basically said the brothers have told too many lies and not enough admissions over the years about what they did before, during, and after their parents' murders.
Most of the time, the people, well, I wouldn't say most of the time, but a lot of the time, the mitigating factors are the brutality of your crimes, do you pose a threat to the public, and have you admitted the lies that you told? That's what they're talking about. And like I said, it's really not about feelings. Like, you can think that they should be let out, and I can understand why some people would think that. This was an absolutely brutal crime that they did, and what they have said happened to them as children is absolutely brutal as well.
But the DA did leave the door open, a little teeny tiny crack, by suggesting that if Eric and Lyle come clean on 16 specific quote unquote lies he says they told, then his office might consider that resentencing bid once again. Family members of Eric and Lyle, who are also family members of Kitty and Jose Menendez, the victims, they were quick to criticize the DA for the position that he's taking. And I'm pleased to welcome Lyle and Eric's cousins, Tamara Goodall and Anna Maria Baralt. Ladies, thank you so much for joining me tonight. I'm sorry this is such a tough day for you. Like, these tsunamis of news have to be really hard for you to process. Anna Maria, let me start with you. The accusation is that the DA says Eric and Lyle have told 20 lies and only accounted for 4 of them, which leaves 16 lies uncorrected. And if only—
Okay, so basically what they're saying, so this has been something that has been presented to them many times, apparently.
only they would cop to these lies about the situation around that crime, then he would reconsider the resentencing. Tell me where you stand on that, and if that's a path forward or a non-starter.
Ashley, first of all, thank you for having us on today. I really appreciate you allowing our voices to be heard alongside of his. And the very first thing I want to do is correct an urban legend that he keeps repeating, which is that Lyle and Eric kneecapped Jose and Kitty. That did not happen. That is not the case. If you look at the crime scene photos, you'll see a wound on Jose's thigh. Both kneecaps are intact. So I'm not sure where he got that from, why he keeps repeating it. But just first off, that is not true. So the second thing I want to say is that it was made very clear to us when we met with the past administration's resentencing team that resentencing was about rehabilitation and life post-conviction. So this constant replaying of the original crime and this laundry list of quote unquote lies that were addressed during cross-examination, I'm not sure why he thinks this is relevant. I really don't. That is not how it's explained to us. Those are questions, remorse, accountability, those are questions for the parole board. They are not for this. This is about rehabilitation and where the victim's family stands.
Here's another thing too. If this was a self-defense killing, to go to the lengths to cover it up is, you don't think that they would go that far to cover this up. That's all I'm saying.
So I always think about the technical legalities of, these 3 pathways are all different. And they're still all in play, even though 2 of them are not looking as good. And that second one, which, was sort of dashed last week or the week before, was the habeas corpus petition for a brand new trial. That would be based on the original trial, the original defense, and the maintenance of the fact that they said it was self-defense. The DA says it wasn't self-defense because you've got to be in imminent danger. So is it necessary for Lyle and Eric to technically maintain that defense until that habeas thing is out and gone, in order to keep that second path alive? Meaning they couldn't possibly do, even if they wanted to, they couldn't possibly admit to these 16 things because it will dash pathway number 2. Does that sound, I'm not sure if I'm being as good as I should be, but take a stab at that if you would, Tamara, and tell me if that's something that hamstrings the boys' attempts to even come into, you know, satisfaction with the DA on the 16 requirements.
First of all, thank you. As Anna Maria said, I really appreciate you giving us a voice. I'm really filled with emotion today, especially after Hockman's earlier press conference. So with all of that said, I'm just so disheartened by.
It's honestly from October to this week or this last week, what a change. I was convinced. Well, I mean, the DA got voted out, and I mean that happens, but I was convinced that they were going to be free. I was convinced. I still think at some point they probably will. I'm not saying I agree with that or not. I just know how these high profile cases happen or how they work. I've seen it happen before. They'll probably be offered at some point an Alford plea. And, you know, I don't know. That's what I would think.
All of the same regurgitation of all of the same points from 1989 through 1996. Like, there is nothing new that he has said. And truly, what this is evident of, at least in my mind, is that he is so focused on the past and he has not demonstrated any understanding of what their activities and their work has been since they have been incarcerated.
Now, one thing that you have to look at is that they have been exemplary inmates. That's a fact. I mean, that there's no disputing that they've done a lot of schooling and apparently helping other people in there. I mean, I've read all kinds of stuff, but I get it. I also get that, you know, that they were sentenced to life in prison. What do you want me to do?
As far as the habeas is concerned, we did not know of the letter until well after the conviction, and Roy Rosello wasn't about to come out and say anything in 1996. He was not in a place to do that.
No.
So we have those two pieces of evidence now, which allows, in what has been explained to me. Now, I'm not a lawyer of any sort, but has been explained to me that this is applicable. Both pieces are applicable. And when Andy wrote that letter or Andy received that letter, come on, you're 13, you're putting it away. And like Anna Maria has said previously, you're picking up the phone at that point. You're not, I mean, do you think at 13 you really understand, especially in 1989, what the implications of that, something of that magnitude is going to be? So, you know, with that, I'm really disheartened at a lack of understanding and the fact that Hockman feels this need to keep comparing this case to Sirhan. They are just different. They are on different levels altogether. So, I mean, enough with that. Truly, it's Eric and Lyle have their own case.
I actually agree with it. I agree with that. I'm so tired of hearing about Sirhan. Well, Sirhan's case, it's like, dude, come on. I want to hear about Sirhan anymore. Let's just talk about their case. Guy's obsessed with Sirhan. Well, he was 20. He's like, I know what he's doing. He's looking for precedent, but it's like, I don't think they line up, but I'm not a district attorney, nor would I ever want to be one.
And it has nothing to do, it's not comparing apples to apples.
It's definitely different. That's for sure. I mean, Sirhan did not even know the man that he.
It's not even close, dude. It's not even in the same ballpark.
Was shooting, and he attempted to kill 5 other people.
Exactly.
And they were unknown to him as well. I would be concerned about releasing someone who was that, you know, unconnected to his victims. There seems to be a real connection clearly between Lyle and Eric and Jose and Kitty, obviously. Let me ask you this, Anna Maria. Uncle Milton, that's Kitty's brother, died recently, which was the last holdout to supporting the release. So now there is not one family member who is alive who supports keeping Lyle and Eric in prison, which is huge, right?
It's almost like they're kind of frozen in time, if that makes sense. You know, Newsom is busy with his podcast. Yeah, I mean, like I said, the Sirhan thing really is just I don't get it. Kelsey gifting 5 memberships. Thank you, Kelsey. It's very kind. But yeah, they're not middle-aged. They're past middle age. I mean, well, I don't know, 52. If you're going to live to 100, and if Lyle's going to live to 114, then I guess they're middle-aged.
It's very unusual to have victims' family members all in support of releasing the killers. It's almost unheard of. Do you feel as though that has fallen on deaf ears? And I ask that mostly because I see just recently, I think even just today, you have filed a complaint with the Attorney General about the DA and said this is a Marsy's Law violation. The news conference today, we weren't informed of it as victims, and we have the right to be informed. We feel we've been, I think you said he's been hostile, Nathan Hochman, and patronizing and aggressive. Where does this go from here? Are you finished having conversations with the DA as the victims' family members? Because he's technically your lawyers, right? And our lawyers too. Is that done? Is that, you know, is that chasm unclosable?
So that should I just don't know. Sirhan, I mean, God, he's been in prison longer than Nelson Mandela, Nelson Mandela, but serving a life sentence for the 1968 assassination of the Senator Robert F. Kennedy. But he came up for parole in 2021. He tried to kill 5 other people. I mean, it looked like he was trying to do a mass murder. So they're just really different cases. They're not the same at all. I don't understand the comparison, to be honest with you. Middle-aged is 40, 45 to 60, 65. It's weird. And condescending. I mean, he was like a politician. It was like political. It wasn't like he didn't kill anybody that he knew. He just knew of. I mean, it's just such a different case. That's what makes this case so frustrating and so interesting and so sad, is that, I mean, you have 2 boys. At the time, they were teenagers that were just flat out, you know, our parents abused us and we killed them because we were scared. We were scared for our lives. Not saying that they couldn't have been scared for their lives, and by no means do I think that their father was this beautiful, nice man. I do not think that at all. I think he was a top-notch asshole. I think that he was controlling. I think that he was a lot of things. I don't doubt that they were abused. I really don't. But that crime scene is rough. The premeditation is rough. Hochman is a heck of an arrogant DA. It's not bad enough that he treated the family horribly, but has the audacity to demand Eric and Lyle tell the truth, and he will consider resentencing them, and only reconsider it. He's not promising them anything. He flat out doesn't think they should go anywhere, which is such a huge change from was it like October, November of last year? Like, I thought that they would be out by Christmas.
Well, apparently, since he did not notify us ahead of time before he went and did this press conference. That is a violation of Marcy's law. From what I understand, it was actually Tamara, who's with me today, who was the name on the complaint about the meeting that we had. As far as Milton is concerned, he was the last family member who was going to be actively fighting against the release of law.
Well, you got the spending, you got was it the safe? I think at one point he was sleeping with the safe. Eric or Lyle, I think Lyle made Eric do that. Just because they were abused, don't give them the right to murder. They were adults. They didn't have to go back home. I get that too. I'm not, they murdered their parents flat out. I mean, but there are mitigating circumstances. And then once again, I'm not advocating for them to be released or not released. I'm
Lyle and Eric. And I think that should say something. It begs the question of whom exactly is District Attorney Hockman serving?
Yeah. All right. I've heard enough of that. Okay, here. This is interesting. All right, so this is Suzette. Thank you, Suzette, for pointing this out. But it says Gavin Newsom on Menendez Brothers. They're going in front of the parole board in June. Big update in the Menendez Brothers case. California Governor Gavin Newsom revealed when Eric and Lyle will appear before the parole board. Gavin dropped the bombshell news Tuesday on his new podcast. Great. Dropped it on his podcast. Announcing the convicted killers will go in front of the parole board June 13th for a hearing. The governor says after the hearing, the parole board will finalize their risk assessment and send it to his desk. And he'll consider their findings as part of his decision on whether to grant clemency in their case, which would set them free. Here we go. Eric and Lyle have another path to freedom here. Gavin says the risk assessment will also be sent to the judge for possible resentencing, and a lighter sentence could spring them from prison too, based on time served. Los Angeles County District Attorney Nathan Hockman is on the record saying he doesn't think the brothers should be resentenced, but Gavin circumvented the DA, and it looks like there's a real shot that they are going to get freed. So yeah, that's where this is headed. But it doesn't, whatever the parole board, he doesn't have to go by what the parole board said. He can do whatever he wants. It's a formality. Be interesting if parole board rules, they no longer pose a danger to society and set the wheels in motion. Do people think that they are? Are there people in here? Are there people that think that they are a danger to society? I am curious about that. If you do, put a 1 in the chat. If you don't, put a 2. If you believe they're a danger, put a 1. If you don't, put a 2. I am curious. Yeah. Interesting. Two, but keep them in. That's interesting. Yeah. Yeah. It's interesting. Mary's undecided. 1 is if you think that they're a danger. Well, that would mean yes, but it's just like Suzanne Smith. She wouldn't admit her guilt at her parole hearing. It's an interesting one. I don't know, man. It sounds like they're gonna get out. If we're just, that's a sick Nike jacket. Um, Hockman spent all that time. Hockman spent all that time just being like, they shouldn't do this, they shouldn't do that. And then Newsom's like, put him in front of the parole board and I'll make my decision. Yeah. It'll be interesting. So I wouldn't be surprised if they're granted clemency. They absolutely have, but it's not, but also they were sentenced to life. So if you think that, a lot of people think that that was an unfair sentence. I don't know if it was or not. I think one already did. I think when, I think Lyle already did that. I think when he thought that he was already getting out, I think he already filed for divorce, didn't he? Or maybe it was one of them. I don't remember which one, but they certainly did. But I don't remember which one did. Let's see here. I'm sure that there'll be stipulations. I don't know what those would be, but probably they'd be on some sort of parole. Maybe like a 10-year one, maybe. I don't know. I agree. That's what I'm saying. That's why this thing is so convoluted. It's so, it's just, it's hard to say one way or the other. I don't know. I mean, like I said, nah, where do you live? You can have them. Yeah. Not yet, but they're separated from the wife, but remain best friends, her words. That'll change probably, but I don't know. Anyway, it's interesting to see where this will go, and we'll keep updated on it. And let me see here. I appreciate you guys being here. Thank you so much for hanging out. Catch you next time.